Zaczynamy nasze spotkanie po spotkaniu, które mieliśmy w poniedziałek. Dzisiaj mamy kolejne z cyklu naszej współpracy z Chinami. Dzisiaj będziemy mówić bardziej o tej stronie ciekawszej dla Polaków z naszego punktu widzenia, czyli tego, co się dzieje w Chinach. Ja może na początku oczywiście przedstawię nas, jeśli Państwo nas nie znacie, bo jesteśmy grupą, która nazywa się Omni Bridges. Z tej strony jest Omni Modo, czyli Tomasz Osiej, moje dane osobowe, i ze mną Michał Czarnecki, który reprezentuje Omni Modo, ale też naszą kancelarię Osiej i partnerzy. Po drugiej stronie mamy naszych partnerów Shanghai Bridge Technologies i osoby, które opowiedzą nam o tym, co się dzieje w Chinach, w państwie środka, ze środka, bo takiej możliwości w Polsce jeszcze nie mieliśmy. Wszystko to łączymy w jeden projekt, o którym mówiłem, który się nazywa Omni Bridges i którego strona za chwilkę będziemy prezentować i wszystkie treści będziemy Państwu przedstawiać. Dzisiaj chcemy opowiedzieć o tym, co się dzieje w Chinach. Wszystko to się bardzo ładnie łączy oczywiście z naszą tematyką, ponieważ zajmujemy się ochroną danych, będziemy się na tym koncentrować, ale będziemy w przyszłości mówić o wiele większym wachlarzu spraw. Zaczynamy od tego. Ja ze swojej strony bardzo dziękuję i oddaję głos.
To ja jeszcze pozwolę sobie uzupełnić. OM Bridges jest to inicjatywa, którą uruchomiliśmy niedawno. Ma ona na celu wymianę doświadczeń, a także wsparcie podmiotów zarówno europejskich, jak i azjatyckich, w szczególności chińskich, jeżeli chodzi o przepływ wiedzy, implementację pewnych rozwiązań, doświadczeń, no i oczywiście wsparcie biznesowe. Także z nami są Helen Tang i Łukasz Sosnowski, prawnicy wspierający korporacje międzynarodowe, zachodnie na rynkach azjatyckich, szczególnie chińskich. Posiadają oni unikalne doświadczenie, bo łączą tą wiedzę azjatycką z pozaazjatycką, no i władają również więcej niż jednym językiem, czyli też chińskim, angielskim. Łukasz jest multilingwistą, mogę zdradzić ten sekret i oddaję Wam głos.
Thank you, Tomasz. Thank you, Michał, for the amazing presentation of our project. As Michał and Tomasz said, I'm Łukasz Sosnowski. I'm a Polish attorney at law based in China, in Shanghai office. I'm the part of the Shanghai Partners Bridge, who assists the foreign companies here in China in doing business in safely and legally effective way. We have the pleasure of teaming up with Omni Modo and build up a new platform that will navigate you through the complex matters of the data protection in China and in Europe. Today with my colleague Helen Tang, amazing PRC lawyer based in Shanghai, we will be conducting a webinar on how to make money safely in China, but especially in the view of the PRC data security framework, which is pretty complex. You will see it later. And let's start. Maybe I will put right now the presentation and we can start it. I will show the Please confirm me how you can see. Okay.
Yes.
You can see that.
Perfect.
You can see the presentation. So the data protection system in mainland China right now is in a period of change, which is very interesting for me as a foreigner lawyer, with significant progress of data protection legislation in recent years, especially in 2023, 2022, 2021, when the PIP law was approved here in China. What is interesting here for this region, that this is no single comprehensive data protection law in China mainland. Instead, the rules on the protection and security of personal data are part of the complex framework and can be found in various laws and regulation decisions and so on. My colleague Helen Tang will introduce you to the three main pillars of the PRC personal data protection framework. The presentation will be divided in 5 main topics. During with Helen, we will discuss of the complexity of the China data protection law system. And so the agenda will be as follows. First, we will start with the significant events of the data security in China in recent years. Then we will go through the brief introduction of major data security laws of China. And then we will speak about the major obligation for the entities, especially foreign entities in data security laws of PRC, which might be very interesting for you viewers. We'll be also speaking the most important part in China, which is what are the risk and cost for the overseas company while doing business in China in terms of data protection. And at the end, we will speak about some practical advice for those who enter China market, and we'll provide some case study of certain companies who are facing recently the problems with data protection regime here in China. So let's start with the first topic. I will give the voice to Helen, and she will provide you very briefly about the significant events of data security in China in recent years.
Okay. Hello, everyone. I'm Helen Tang. I'm very honored to make this webinar on behalf of my company, Shanghai Partners Bridge. Okay, so thanks for the introduction of Thomas and Lucas. Let's begin. Okay. Let's see an example of significant event of data security in China in recent years. Yuantong Express got a rectification order for leakage of 400,000 pieces of Chinese citizens' personal information. Well, Yuantong Express is one of the biggest express companies in China. Back in 2018, it was involved in trading 1 billion pieces of Chinese citizens' personal information on dark web. In 2020, Yuantong reported to Shanghai police that it was stolen 400,000 pieces customers' personal information, including names, mobile numbers, addresses, and other information, and so on. And after investigation, police found out criminals illegally rented Yuantong employees' accounts of internal system and copied, sold customers' personal information for 1 RMB per piece on the internet. Shanghai office of the Central Cyberspace Affairs Commission, which is one of the departments in charge of data security, interviewed Yuantong and issued a rectification order immediately. And according to According to cybersecurity law of the People's Republic of China and data security law of China, companies shall build cybersecurity grading system and protect data in compliance with his catalog and importance level. Customers' personal information as core data shall be stored after anonymization and encryption. Employees shall have graded access to different levels of data and take responsibilities. Companies shall also develop an emergency plan for cybersecurity events to immediately respond to such security risks as various attacks and intrusions. Apparently, Yuantong Express failed in every way of personal information protection, and so sad. Let's see another case. 15 million penalty on CNKI.com and apps. Cyberspace Administration of China issued a ticket of 15 million to CNKI. CNKI is a journal and paper database and an academic platform provider for its illegal collection of personal information. These are the violations of CNKY. You can check it one by one. First, collecting unnecessary personal information. 2, collecting personal information without user proper permission. 3, failure to release in an express way of collecting and user policy of personal information, for failure to provide the function of ID cancellation, failure to delete the user's personal information after ID cancellation. I believe we can tell these scenarios are illegal from a natural sense. We will talk more about it in our later sections. Next, I will give a brief introduction on 3 major laws as the most important data security laws of China and more details in legal use of data. All right. Okay. Let's first see different concepts of data security or data protection, GDPR, CCPA, and data security laws of China. Okay. GDPR. I believe this is the specialty of our dear partner Omni Modo, right? And these 3 are the subject matter and objectives of the Article 1. Yeah, we can see the purpose and the main point of GDPR is protecting natural persons, personal data, and the free movement of personal data within Europe. Okay, let me switch. Okay. And this is Article 4, the definition of personal data. So the concept of data security as in GDPR is about protection of personal data, which we call personal information in China laws. It's mainly about natural persons' human right. And this is the CCPA's definition of personal information as the core concept of the law. It's also about the protection of personal information, right, Lucas?
Yes, it's the same.
Yeah. So what about things in China? We have 3 major laws. One is cybersecurity law of the Chinese Republic of China. 2, data security law. 3, personal information protection law. We call it PIPL of China. And I have to say data security means more than protection of personal data in China, but includes protection of non-digital data, non-personal information, and operation security of internet. What do you think, Lucas? What's the difference?
Yeah, this is the difference comparing with the GDPR, because we are just talking about the wide range of data, right? All right, Helen, and we have like different providers. So, for example, the cybersecurity law most regulate activities of internet operators and internet service provider in China. Also, like, and we have this very important approved in 2021 personal information protection system, which concerns specifically for the personal information. So this is the major difference, that all the that the framework, Chinese framework system is pretty much complex. We have 3 different legislation and also a lot of different guidelines, decision, measurements of the authorities which specify these 3 main laws in China.
No, you're really expert of China.
Yes, thank you very much for that.
Well, okay. Let me clarify the main content and relationship of these 3 laws so everyone can have a clue. It's not that complicated. Okay, so first one, CSL. What's the subject matter of it? We can see, I summarize it as 1 to 3, right? Please pay attention to the red words. It is from the view of internet operators and internet service providers as subjects, like Baidu, Sina, and Chinese app stores, which must locate in China. And about B, government also needs to comply with its special obligations, or else it will be punished too. And C, it includes the punishment for government, departments, civil servants, and officers in their violation. Of course, the normal business entities and the persons. This is CSL. So let's see DSL. Well, the right words are the most important. It protect and keep data legally usable and continuous security right. It includes digital and non-digital data, and all forms of data, not limited to personal data. And B, to regulate data processing activities. And 1 and B are from the view of data and data processing as an object, like the procedure of collecting data, when to provide and delete certain data. So we can say it's totally different from CSL, right? 1 is from the subject, 1 is from the object, okay? And C is about the jurisdiction. We'll talk about it later. And D, to clarify the supervisors and the responsibilities of relevant departments. It's the same. D and E are the same with the CSL. Okay, let's see. What about PIPL? To protect personal information, we all know about it, right? It's from the view of protection of personal information. It's and citizens' human rights. It has both views from the object and the views of subject. The B and C are the same with the other 2 laws. So we can see PIPL is closer to GDPR and CCPA, which it actually referenced in his draft. But it's not enough of international companies in China to comply with only PIPL. Otherwise, companies will face unexpected punishments and law risks from other data security laws. So these 3 laws have overlapping parts, but also independent parts. These true or false questions will help us understanding. So Lucas, could you help me to answer this question, all right? First one, CSL protects all forms of personal information, true or false?
No, of course it's false. It protects only digital personal information.
Right, you're clever. Count for you. And 2, PIPL protects only digital personal information, true or false?
This is also false because it protects all forms of personal information, not only digital, also non-digital.
True, that's correct. And 3, DSL protects all forms of data, true or false?
This is true. It protects digital and non-digital data.
Yeah, I can't fool you. You're so clever. All right, I think it's clearer now for everyone that these 3 laws have their own points and overlapping areas. So there are other laws on data security except these 3, of course. But we can see obligations and provisions about data protection or cyber safety protection in a lot of laws. For example, criminal law on gardening, national secrets, regulation, map management, and so on. It's a lot. It requires company to comply with not only 3 major laws regarding data security, but also subdivided provisions and regulations in certain fields. But they also have some common ground. For example, all information and data collected and generated within the scope of China shall be stored and processed locally in China. That's the common point. And we have some national standards as well involving data security. Some of them are not compulsory. We can see these standards ends with GBT and the numbers. That's the number of national standards. From the earliest 2007 to 2022, there's a lot. I didn't list it all. And these are regulations, detailed regulations on the implement of the 3 major laws. We can date back to 2011 for data protection. Some of them are not compulsory, as I said, but reaching such standards and acquisition of relevant certificates are always the best proof for good performance of data security laws. On the other hand, major laws lack detailed provisions and standards. So these standards and regulations are essential supplements. Okay, so what are the major obligations for entities in data security laws? We should check on the jurisdiction, right? Because we first want to figure out the effect on overseas entities. Yeah, it's special from the domestic companies. What does the CSL say? Article 2 and Article 75. Please pay attention to the right words. I always highlight the key point of articles so everyone can have it easily. The law shall apply to construction, operation, maintenance, and use of network within the territory of China. And in the event that any overseas establishment, organization, or individual engages in any activity that endangers critical information infrastructure of China by attack, infusion, interface, or damage, such activity cause severe consequence, then this law also applies to you. So CSL is generally a domestic law for China. If a network operator of internet services locates abroad with no branch and office in China and does its work outside China, then even though the Chinese citizens may use such service, it doesn't comply with CSL, except for the scenarios it will harm the country's interest or public interest. On the other hand, if an overseas entity have branches or offices in China and provide internet services within China, they shall comply with CSL. About DSL, this law applies to data processing activities, blah, 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 within the territory of China, and data processing activities outside China damages the national security, public interest, or the rights of citizens also apply. Okay, same with CSL. DSL is basically a domestic law. On the other hand, if an overseas entity processes data outside China but harm the public interest, Chinese citizens' human rights, or national security, they may be punished by CSL when they enter China. The third one, the PIPL, the law applies to the processing of the personal information of natural persons within China, also within China. But this is the basic principle. We have to check out the exceptions at the second paragraph. If a processing of the personal information of natural persons, if the processing of the personal information of natural persons who are in the territory of China, but the processing is outside of the territory of China, then they have to check up on this law under the following circumstances. The first one is to provide domestic natural person, is to provide Chinese citizen with products or services. The second is the activity of domestic natural persons are analyzed and evaluated. It's very similar to GDPR, actually. The third one is an open-end, other laws requirements. So PIPL shall also apply to overseas entities, whether or not they have branches in China, just for purpose to provide service or products to Chinese citizens or to assess and value Chinese citizens' activities. About this Article 53, personal information processor outside China, as we said in the last section, shall establish a special agency or designate a representative within the territory of China.
So every Helen, every Polish company who will process the data outside of territory of the Public Republic of China, of the Chinese citizens, they have to establish a special agency here in China or have the representative within the territory of PRC, right?
Right, for the last two purposes, as I talked
As
about.
I told before.
Yes.
Okay, so
Right.
this is very important for the foreigner companies.
Yes, right. So it is also required such entities shall establish a special agency or designate a representative in China to be responsible for processing matters relating to personal information protection. And they also should submit the name and contact information to the authorities. So to sum it up, as an overseas company entering China market, if you plan to set branches or offices in China, you need to apply all three laws. If you process data and provide services outside China, like some overseas online shopping website like Bloomingdale's, I usually shop there, buying dresses. PIPL is the most important law you should focus on. However, your Chinese partners will also require you to comply with Chinese laws and their privacy policy. For example, you may want to use Alipay WeChat payment in your products for Chinese customers. Then Alipay will only cooperate with those who comply with Chinese data security laws in order to reduce Alibaba's legal risk in China. So it's not only about jurisdiction, it's crucial for global companies to understand what liability they may take, the allocation of responsibilities, and the role of data processor and controller in a cross-border transaction and the Chinese data laws. So you can do good contracts, reasonable deals, and efficient negotiation with your Chinese partners, right, Lucas?
Right.
Exactly. Okay, so we're going in deep, all right, with the laws. Let's see what are the major obligations for entities in data security laws of China. I didn't list all the obligations, but these are the most important ones. I emphasize the important part with the right words, so you can easily see it. As for CSL, Article 21, the state adopts like graded system for cybersecurity protection. And network operators are required to perform the following obligations. The first one, they should have internal security management system and operation instructions. Number two, they should have proper technical measures to prevent virus attacks and intrusions. Three, the companies should take measures to monitor and record their operation activities and keep the record for no less than 6 months, because these records are good proofs for good performance of the law. It will protect you later in emergency events. 4, we should have data classification and backup and encryption of important data like personal information. It should be anonymization, sorry. And Article 25, and network operators shall develop an emergency plan for cybersecurity events like leakage and attacks. If the amount of PI is the personal information, I call it PI, processed by an entity reaches the standard of national cyberspace administration, then such entity becomes an operator of critical information infrastructure. The obligation will be more and heavier. And if such a critical information infrastructure wants to provide information or data abroad for business purpose, they should take a security assessment. Because as a subject matter, CSL is majorly applied for network operators and internet servicers. They're usually big companies, so the obligations are very heavy, we can see. About DSL, they also require data classification and protection system, which on the basis of granted protection system for cybersecurity. We can remember the graded protection system is required by CSL, right? Moreover, processors of important data shall specify the person responsible for data security and the management board and implement the responsibility of data security protection. Okay, let's look at Article 30. They should have a regular assessment on risks. To be specific, the risk assessment report shall include the types and the quantities of important data processed, information on data processing activities carried out, data security risks faced, and countermeasures thereof. Let's see the last but not the least, PIPL. PIPL have very detailed obligations on personal information protection. Okay, a personal information processor should have the internal management systems and operating procedures. Do they sound familiar to you, right? It's almost the same with the other two laws, but they have different names and different key points. To implementing category-based management of PI. Now take corresponding technical security measures, such as encryption and de-edification. And of course, number 4, education and training on a regular basis. Number 5, they should also have emergency plans. We can see the similarities between PIPL, CSL, and DSL. They all require systems with different key points and requirements on that. Article 52, for PIPL, you need designate a person in charge of personal information protect and also make public the contact information to the people and submit the name and the information to the authorities. It's same with DPO, right? In GDPR,
Right.
what do you think?
No, it's like the PIPL is a bit different from the it's similar in the one way, but it also have some different provision regarding to GDPR. When I was advising the foreigner clients, I saw like the sensitive data definition is a bit different comparing with the GDPR. And also there are specific provision for different sectors. Sure. Like, for example, for the automotive sectors, different requirements for the health and medical sectors. So there are specific requirements for those sectors. And also what is different is this requirement of separate consent. It is also unique for the PIPL. Right.
True. Actually, PIPL doesn't have very detailed provisions on DPO as GDPR, but also it's a very important role in personal information protection. So until now, we can see the connections of the three laws, but for 55 and 57 are very unique in PIPO. 55, conduct an impact assessment on personal information protection. On what? On the following processing of information. First, if you are processing sensitive personal information. Second, if you're using personal information to make automatic decision. 3, entrusting others to process PI. Or providing other processors with PI. 4, providing PI to overseas parties. You should have an assessment on that. And 57, in an emergency that PI has been or may be divulged, so you have to immediately take remedial measures and notify the authorities, of course, with the users. It's the same with GDPR too. The obligations of PIPL are more for those PI processors who provide important internet platform services with a large number of users and a complicated business type. So we can tell the common parts of the three laws that they all require compliant systems, assessment and reports on regular basis and data outbounding. That's important. And 3, education and training. What risk and cost and overseas company may encounter in China? Let's see what the three laws say. All the punishment of the three laws follows the principle of double punishment. They punish both business entities and main persons. By main persons, they can be supervisors directly in charge of the business or other direct liability persons like CEO, CTO, COO, or just a personnel in charge of data processing. It's very broad. This is the CSL. The punishment for entities from minor to heavy. From the manner, we have warning and rectification, or like Yuantong Express got. They have confiscation of illegal earnings and a different range of penalty. The penalty we got 10,000 to 1 million RMB. Of course, if you are still in a very severe consequence you made, there will be suspensions of business, winning up for verification, close of website, revocation of business license, and the last not the least, criminal punishment. For main persons, it's almost the same, but they may face 5 to 15 days detention, and the penalties can be 5,000 to 1 million RMB. Please pay attention. If a person who receives public security administrative punishment, they shall not be allowed to hold key posts of cybersecurity and network operation for 5 years. And if such person receives criminal punishment, he or she will be banned for lifetime for those posts. About DSL's punishment for entities. We have a new one, interview and requirement of rectifications. Where there is an interview, because all the emergency in data field, they may be very new, and the department wants to make sure they don't make mistakes. So they need to dig in with some information and the situation. So they want to interview the entities first. Then they will make some decision whether and when to punish the entities. And the second and the third are the same. We have more penalties from 50,000 up to 10 million RMB, or a penalty of 1 to 10 times of illegal earnings. Well, for illegal earnings, it just if the entity is a intermediary servicer of data transaction, it applies 1 to 10 times illegal earnings. Or the last three are all the same. And for main persons, we have penalty from 10,000 to 1 million. It's very, very much for individuals. We can see penalty in DSL is much higher than CSL. The maximum punishment on entities can be 10 million. The maximum of punishment on main person can be 1 million. But PIPL is a bomb compared to the other two laws. Except for the regular punishment, they have penalties below 1 million or 15 million or 5% of previous year's revenue. For main persons, the penalty can be 1 million and also banned for certain period from serving as directors, supervisors, and senior executives and person in charge of personal information protection of the company. But also they have PIPL has special punishment in the provisions. Customers can require indemnification for their loss and damage directly in relation to PI problem. Also, you will get recorded in public credit archives. So PIPL provides the highest administrative penalty ever in history of China for violation of protection obligations of PI. It referenced the penalty of GDPR, which based on scale of business. Now let's look at a case which is very significant in China. 8 billion RMB penalty for DD app in 2021. Do you ever use DD, Lucas?
Yeah, of course. I'm like using DD every day. Basically, this is like Uber or Bolt in Poland, and yeah, the application is pretty friendly for the users. And how is about with the data protections?
What are their functions?
The functions, you are just asking for a taxi, right? And from one place to another one, and you are just providing your information. You have to register the application on your mobile, giving them all the personal information, right? The mostly is like your name, mobile, and later like a location when you are to ask the taxi for or the car for the destination you want to go.
What's the similar app in Europe?
This is mostly like in Europe, mostly I would say Uber or the Bolt application. There's also several local application, like some taxi application for the mobiles in different countries.
Okay, thank you for your background. This is the most penalty in history in China for violation of all 3 major data security laws, which equals over 1 billion euro. Didi is one of the earliest and biggest taxi platform. It still has almost 500 million users until now. So let's see what Didi did wrong. 1. Collecting more than 11 million screenshots from users' mobile phone without permission. 2. Over-collecting more than 8 billion messages from users' clipboard and application lists. 3. Over-collecting without users' permission more than 100 million passenger facial recognition information, 53 million pieces of age information, 16 million pieces of occupation information, 1.3 million pieces of family relationship information, and 153 million home and company addresses. This is disaster, right?
Right. Wow.
Because all these information are all sensitive information, but not necessary for APP's function. Why do you need to know my age, the name of my aunt, and my job to call me a taxi? It's
Right.
outrageous.
It's too much.
Yeah, it's too much. 4. Over-collecting 167 million accurate locations from passengers. Do you think the passengers are only the victims? No, the drivers are victims too. So 5, over-collecting nearly 143,000 pieces of driver education information and storage in clear text of 57 million driver ID numbers, which means these identification were not anonymized when in storage. 6, analyzing without clearly informing passengers 53 billion pieces of passenger travel intention information, 1.5 billion pieces of resident city information, and 304 million pieces of long-distance business or tourism information. 7, repeatedly requesting unrelated call permission when passengers using ride-sharing service. 8, failure to demonstrate to passengers the purpose of personal information processing in an express and accurate way. So we can see every point is severe scenarios in textbook. So I wonder if they did this on purpose so they can be in textbook.
Of course, they can like later sell all the information like that. From my perspective and my experience, China is like is like masters in collecting data in everywhere, in everywhere and every way.
Then you can receive like more and more advertisement.
Right.
But oh my God, this is ridiculous. So I summarize from PIPL and relevant regulations some scenarios in which internet products illegally collect PIs. Let's see what Didi did wrong with it. Failure to release rules of collection and the usage of PI. You don't have privacy policy, or you don't tell the users the rules of collection and usage of PI, you'll be in trouble. Or the privacy policy is very hard to achieve. It's not clear, it's too long. It requires more than 4 times of clicking to achieve it. Or it's in another language than the local language. It's all problem. It's illegal. Failure to express the purpose, method, and the scope of collection and the usage of PI. You have to list every purpose of collection and usage, including those of third parties SDK. If you don't show like proper information on changes of it, it's wrong. You have to notify the users when they are giving permission for collection sensitive PI or notifications too hard to understand. It's illegal. The content cannot be too hard for common man, cannot be too long, too complicated. The figures cannot be too small. And in failure or provide access to revoking permission by users is still illegal. Well, collection of irrelevant PI with the service in violation of necessity rule. And then necessity rule is also an important rule in GDPR, that you cannot collect more than what you need to provide the function of your product. I think DD violated this section seriously, right? They collect the information with from nowhere, and it's very illegal. And if the frequency of collecting PI exceeds the actual needs of function, is still wrong. Enforcement on users to permit collection of PI only to improve service quality and experience, develop new products for these minor purpose is illegal. Refusing to provide service is denied by users of multiple permission at the same time. You can only ask for permission when user use relevant function, but not asking users permission for all the collecting purpose at the same time. And for this function, failure to provide deletion and modification function is also violated by DD. You should provide, first you should provide the channel of these functions. Second, it should be true. It cannot be like a fake act to the users. The users delete the information on the phone, but actually in the backstage, it's not. So it's still illegal. And these functions must be provided in time, as long as the law requires. It's 15 working days. We can remember the 15 working days is most of the deadlines of these laws. The companies should also build and release the complaint and reporting channels and handle these complaints in time, still within 15 working days. All right, we already, I guess, already finished the main part of the webinar. We have some different suggestions for companies whose business is involving data and PI processing at different stages. For those who want to start business in China from scratch, we suggest a brief assessment by lawyers on company's business mode. It won't cost a lot of money, but it will help company build the structure of data processing and figure out the product's framework, where to put the servers, how to design the data flow so it won't need data outbounding assessment, how to save money for data processing, where to find vendors as data processors. And sometimes in the development of your products, you need to cut in at the right time with the data compliance review, or else the basis of your products can be wrong. Okay, for those who already have some business in China, we suggest an overall assessment by both lawyers and data experts on current products, company governance, and employee management. It can recognize flows and weak points of products and business to reduce risk to minimum in advance. If you are not sure about an overall examination, an assessment on single main products is a good choice too. You can use the compliance template for your other product. We found a number of data security events and mistakes of employees. So regular education and training is a good way to avoid such negligence. And also it's a good proof of due performance of China laws. And in case of data security emergency, please contact lawyers and professionals immediately. We will figure out the right way to respond to different scenarios and reduce the loss to the minimum. Okay, thank you for everyone's listening. Yeah.
Thank you, Helen. It was like very interesting, like hearing about the framework of the Chinese data security system. Maybe I will very quickly follow up in Polish for our viewers. What's the like the resume of the presentation to better understanding of the topics we were like talking about recently, and if you allow it, I will do it in Polish, not in Chinese. Okay?
Sure, go ahead.
Okay. Więc dziękuję Państwu za uczestnictwo w tym webinarze. Jak Państwo widzicie, system prawny w Chinach dotyczący ochrony danych jest skomplikowany, bardziej skomplikowany niż ten system, który znamy z Unii Europejskiej. Mamy tutaj 3 główne akty prawne. Cyber Security Law, mamy Data Security Law i tego PIPLA właśnie bardzo znanego. Zresztą wszystkie te prawa, co jest ciekawe, one były uchwalane stosunkowo niedawno. Personal Information Protection Law of China zostało uchwalone w 2021 roku, co jest bardzo ciekawe. Generalnie Chińczycy i też wszystkie firmy się uczą w ogóle stosowania tego prawa i też przetwarzania danych czy w sieci, czy na zewnątrz. Więc jest to bardzo ciekawe dla mnie jako prawnika zagranicznego obserwować te zmiany, które zachodzą na chwilę obecną w Chinach. Już teraz bardzo Państwa serdecznie zapraszam na kolejne webinary, ale też żebyście Państwo przemyśleli sobie dokładnie biznes. Tak jak Omni Modo daje Państwu niesamowitą platformę, ale też wiedzę w zakresie ochrony danych osobowych, czy w ogóle szeroko pojętych danych w Unii Europejskiej, to również tutaj na miejscu doradzamy Państwu, jak prowadzić ten biznes i jak przetwarzać te dane, żeby problemu nie mieć, bo generalnie w Chinach, jeżeli nie ma problemu, to w zasadzie tego problemu nie ma, ale jak zaczynają się problemy, to te problemy zaczynają być poważne. Tutaj miałem takie ciekawe pytanie od Michała Czarneckiego, który zadał mi pytanie, czy tu jest jakaś jedna agencja, która się zajmuje tą ochroną danych w Chinach. Dzięki, Michał, za to pytanie, które mi zadałeś w wiadomości tekstowej. Co ciekawe właśnie, co jest takim też specyfiką rynku chińskiego, to nie mamy tutaj jednej agencji. No tak jak mamy w Polsce na przykład prezesa Urzędu Ochrony Danych Osobowych, to tutaj w zasadzie mamy taką jedną agencję, czyli oni bardziej mają jedną agencję, to jest ta Agencja Administracji Cyberprzestrzeni i ona zajmuje się generalnie kwestią przetwarzania danych, ale w internecie i tam są nałożone różne obostrzenia, co trzeba zrobić, żeby te dane przetwarzać, jak wyglądają nawet umowy. Oni nawet opracowali takie umowy wzorcowe. Ja jeszcze takiej umowy wzorcowej nie widziałem, żeby ona w ogóle była podpisana, ale trzeba uzyskać specjalne certyfikaty i przejść właśnie taki assessment, żeby móc te dane przetwarzać. Nie jest to sprawa łatwa, zwłaszcza to jest dla e-commerce'u, ale oprócz samej Agencji Cyberprzestrzeni, takiej na poziomie centralnym, mamy również tą cyberprzestrzeń administracji na poziomie prowincji, czy też na poziomie lokalnym. Do tego dochodzą agencje, które są w lokalnych rządach. No i na samym końcu mamy jeszcze te słynne PSB chińskie. Myślę, że Państwo, którzy pracujecie z Chinami, wiecie, co to jest. To jest ta słynna policja i ona nawet zajmuje się ściganiem kryminalnym właśnie tych spraw związanych z naruszeniami regulacji chińskich. Co jest dla Państwa najbardziej istotne w Chinach, to jest oczywiście ten ostatni de facto akt, czyli ten, o którym mówiła Helen, czyli Personal Information Protection Act. On jest dosyć specyficzny, co jest ciekawe, podobnie jak GDPR, on ma również eksterytorialny zasięg, czyli że jeżeli polskie firmy przetwarzają dane osobowe osób fizycznych w Chinach kontynentalnych w celach oferowania im produktów, czy w cenie analizy ich zachowań, to wówczas ten PAPL będzie miał zastosowanie dla takich polskich organizacji i muszą albo ustanowić tutaj agencję na miejscu, bądź przedstawiciela. No to jest ważne w kontekście właśnie też, w kontekście e-commerce'u. Jeżeli Państwo na przykład macie stronę w Polsce w języku chińskim, robicie jakieś kampanie marketingowe z myślą o sprzedaży swoich produktów w Chinach i macie na przykład chiński, to się spotkałem z amerykańskimi firmami. One miały na przykład linię przeznaczoną tylko i wyłącznie dla Chińczyków w języku chińskim, pozyskiwały te dane, to pomimo tego, że były zlokalizowane poza Chinami, to część przepisów PAPL-a się stosowała do tych firm i musiał to przetwarzać i były przypadki, że były za to później karane, więc jakby razem z Omni Modo zapraszamy Państwa do właśnie oceny Państwa biznesu, czy te czy inne przepisy będą się stosowały do Państwa biznesu. Myślę, że rynek chiński jest dosyć ciekawym rynkiem. Macie Państwo, zwłaszcza w kontekście e-commerce'u, ostatnio miałem nawet przyjemność uczestniczyć w innym webinarze dotyczącym stricte e-commerce'u. Tam rozmawialiśmy o tych głównych platformach chińskich. Chińczycy tu w Chinach w zasadzie wszystko kupują przez internet, tu w zasadzie nie chodzi się do sklepów, wszystko to się opiera na aplikacjach mobilnych. One dotyczą, te platformy są i myślę, że to będzie też przedmiotem naszego kolejnego webinaru, bo to jest bardzo ciekawy temat, ale są i platformy do cross-boardingowego e-commerce'u, no i oczywiście te wewnętrzne. No, wówczas trzeba posiadać na miejscu spółkę, chociażby te słynne WOFI, czyli Fully Owned Foreigner Enterprise, które pozwoli Wam handlować na miejscu, bądź prowadzić ten cross-boarding biznes. I też Państwo będziecie otrzymywać dane od chińskich platform i tam będą specyficzne wymogi od Was wymagane zgodnie z prawem chińskim, chociażby kwestia podpisania specjalnej umowy i zapewnienia tej ochrony danych na takim samym poziomie, jakie są wymagane zgodnie z regulacjami chińskimi. Także dziękuję Tomasz i Michał za zaproszenie do platformy Omni Modo. Cieszymy się, że będziemy mogli być częścią Omni Modo i razem pracować i również z chińskimi klientami, którzy coraz częściej idą do Polski oczywiście, do Unii Europejskiej, tam otwierają swoje oddziały, czy otwierają swoje centra serwisowe, czy otwierają również fabryki i w tym zakresie będziemy mogli razem pracować i też ten framework taki i europejski i chiński, tymi naszymi doświadczeniami się dzielić i się rozwijać. Jeszcze raz też Państwa zapraszamy na stronę internetową ombridges.com.cn, która będzie w najbliższych dniach uruchomiona i tam będziemy się dzielić naszymi doświadczeniami i na gruncie prawa europejskiego i na gruncie prawa chińskiego. Będziemy zamieszczać też newslettery, co się dzieje. Tak jak powiedziałem, w Chinach się dzieje dużo, w 2024 roku będzie bardzo dużo zmian, zwłaszcza w zakresie e-commerce'u. Chińczycy chyba poszli po rozum do głowy w zakresie tego transgranicznego przetwarzania danych osobowych, bo robią duże uproszczenia w tym zakresie. Już nie będzie potrzeby takich, czy podpisywania tych umów, czy przechodzenia tego assessment w zakresie określonej ilości danych, to będzie łatwiejsze. Więc tym wszystkim, to jeszcze nie zostało uchwalone, ale przeszło już bodajże któreś tam opinie społeczne, więc niedługo to prawo może wejść i bardzo ułatwi robienie biznesu w Chinach. I oczywiście tymi wszystkimi nowinkami, tymi wszystkimi zmianami będziemy się z Państwem chętnie dzielić i wspólnie z Omni Modo rozwijać naszą globalną platformę. Także bardzo dziękuję Państwu za udział w dzisiejszym webinarze i zapraszamy na kolejne webinary. I Tomasz, oddaję Tobie głos.
Dziękuję Ci bardzo i jeszcze do Helen, thank you for your lecture. It was very, very interesting. It was a little similar but a little exotic, especially about punishment. It was very, very for us. And I was wondering how it was in Poland if we had this kind of I think the CEO will give us all the green light to do everything, but it's incredible. So thank you. Odnośnie naszej współpracy, tak, jest masa ciekawych materiałów, jest tak dużo, że w zasadzie nie wiemy, od czego zacząć. Chyba od tych kar zaczniemy, bo one są takie dla nas naprawdę mega egzotyczne. Ten system jest niesamowity. Będziemy o tym pisać. Otwieramy stronę. Za chwilę wszystko będzie na stronie. Masa ciekawych tematów. Będziemy robić kolejne webinary. Świetne podsumowanie, oczywiście też po angielsku. Bardzo ciekawe materiały. Będziemy trójjęzyczni, żeby było ciekawie, więc to też tym bardziej poszerzy te nasze zasięgi. No i działamy, tak? Jest tak ciekawy obszar, tyle ciekawych rzeczy, że nic, tylko dzielić się. Odnośnie tutaj do Państwa i tego, co się dzieje w Chinach, no bez asysty na miejscu nie ma takiej możliwości, żeby cokolwiek zrobić. Także my tutaj oferujemy pomoc w Polsce, jeśli chodzi o Europę, natomiast w Chinach nie wyobrażam sobie, żeby ktoś bez asysty to w ogóle zrealizował.
Ja tylko uzupełnię, że Helen i Łukasz działają oczywiście dużo szerzej, tak samo jak my, core naszej działalności mamy ochronę danych osobowych, ale też prawo nowych technologii, prawo pracy, etc. Tak, Łukasz i Helen wspierają europejskie, zagraniczne firmy, jeżeli chodzi o rozpoczynanie działalności właśnie głównie w Chinach. Stąd również ochrona danych osobowych jest tutaj częścią ich wachlarza możliwości.
Dokładnie tak, dziękuję Michał. Rzeczywiście pomagamy tutaj już istniejącym spółkom na miejscu w Chinach, również tym notowanym na warszawskiej giełdzie. Mamy sporo doświadczenia w obsłudze zagranicznych, polskich, czy też amerykańskich, brytyjskich spółek. Jest to ważne właśnie, dlatego też rozpoczynamy współpracę z Omni Modo, bo wiemy, jak ważne być na miejscu, jednak obserwować te wszystkie zmiany, też widzieć to od środka. Jakby to jest kwestia też i specyficznego funkcjonowania tutaj urzędów, sądów. Dzielimy się praktyczną wiedzą, bo my nie jesteśmy teoretykami, tak jak Omni Modo, platforma, czy też kancelaria Tomasza Osieja ma praktyczną wiedzę i przekazuje tą praktyczną wiedzę, więc my pomagamy biznesowi w praktyczny sposób. Widzieliście Państwo dzisiaj dużo przepisów, no bo ten system jest bardzo skomplikowany, ale myślę, że już następne winery będą bardziej praktyczne. Będziemy bardziej praktycznie dyskutować o prowadzeniu biznesu w Chinach i też wszystkich wymaganych regulacjach. No ale musicie zrozumieć Państwo, że właśnie z uwagi na taką specyfikę tych Chin jest to temat tutaj bardzo złożony i obejmujący wiele agencji, wiele instytucji, wiele urzędów, więc tutaj pomoc specjalistów jest wskazana. Więc jeszcze raz dziękuję za zaproszenie do współpracy z Omni Modo. Bardzo się cieszymy z Helen. We are very happy, Helen, right, to cooperate with Omni Modo, which is the biggest GDPR platform in one of the biggest in Central Europe, and to cooperate with them. So we are very happy, and we will be making the next webinars and sharing our practical knowledge about not only GDPR but also intellectual property law here in China and how to safely make the business here in China, right? And we'll also share our clients to go and to also work in Europe, and Omni Modo is like the amazing partner to share their knowledge and help them to safely carry on business activity in Europe.
Yeah. So once again, thank you very much. 谢谢你 und 再见.
不客气，再见。
再见大家.
Do zobaczenia.
Dziękuję.
Do zobaczenia.